brothers and sisters, and friends, and I see some enemies. In fact, I think we'd be fooling ourselves if we had an audience this large and didn't realize that there were some enemies present.
Is jurisdiction one of the elements of the alleged code violations here today?
Well, Mr. Azar, I can assure you that this court does have jurisdiction to hear this matter.
I appreciate the answer that you gave, Judge. However, I'm looking for, yes, the jurisdiction is the element of the alleged code violation here today, or no, it is not. Could you please clarify?
So you,
take another whack at that sentence. That was butchered.
Okay. I appreciate your answer, Judge. However, I'm trying to clarify, is jurisdiction one of the elements of the alleged code violations here today?
And I just told you that this court has jurisdiction to hear this matter.
This fucking tactic works really well on me. I don't know why I'm not fucking seeing it, but like every single time.
So what's the tactic? So you describe the tactic that he's using. Try to describe what the judge is trying to get you to think or do.
He's trying to knock me down a different path. He's trying to get me to go down.
I get that. Be a little bit more specific.
He's not answering my question. He's answering the question that he wants me to hear, and not the question that I'm asking.
Is he maybe trying to make it sound like the question's moot because he's already made his determination? Like, why are you trying to investigate when I've already told you the ruling? And he's like, I've made it all moot because I've already told you the answer. Right? That's his tactic. He's trying to say, well, I've already given you the answer, so you trying to check my math is fucking not gonna, is something you shouldn't do. Shame on you for trying to check my math.
So specifically what I'm doing is I am presuming jurisdiction.
Oh, okay.
And then getting on to you for daring to ask for anything but the conclusion. See, judges think of their world as a series of conclusions, and what went into them is nobody else's business, really.
Objection, Your Honor. Point of clarification: are you presuming jurisdiction over me here today?
Oh, well, we're not presuming anything. We're simply taking judicial notice of it.
What happened to your other question? Your other question was pretty good. What happened to it?
Well, the other question was abandoned, apparently, because of I got taken down.
At least you noticed that you did.
What was your response again? Can you repeat, please?
I said, no, we're not presuming anything. We're simply taking judicial notice on the matter of jurisdiction.
Right. So you're basically claiming that it's like common knowledge that you have jurisdiction?
Yeah, I'm claiming that it's just an indisputable thing. It's like, I'm claiming that, by saying judicial notice of jurisdiction, I'm saying I'm taking judicial notice that the Earth is round.
So what's maybe a counter tactic to his approach where he said, your question is moot because I've already made my decision. That chapter is closed, and there's no real reason that I can see to ever talk about what would make it right or wrong again. Why are you trying to convince me about the issue of jurisdiction when I've already made my final ruling, my final word on it? Why are you still even discussing it?
Would I ask?
No. Let's not go back into character yet. Okay. What is the reason you have for wanting this information?
Because I want to actually expose that they don't have jurisdiction. Therefore, it's not valid. Like, I shouldn't even be here right now, basically.
So you're exploring the truth. You're investigating so that you can get on the record the reality of the situation for other people than the judge, right?
Right.
Okay. Now keep that in mind. If the judge isn't God, we're discussing this and revealing and exploring, call it exploring and investigating this issue for the record for posterity, for your own understanding. Maybe it'll reveal something that helps you with your defense. Even if you were a statist, it would be good to get this information so that you could then understand maybe some, oh, hey, that lets me know that, by the way, this prosecutor screwed up in this and whatever. So it's like, great, his conclusion's all good and well, not acceptable, not convincing, as it were, but that isn't really what you're investigating. You're trying to be informed of the cause and nature. You're not just trying to be informed of his conclusion. You're trying to be informed of the details so that you can construct your defense, your appeal, all these things. He's being too short-sighted. And it's like, okay, well, your decision aside, there's a whole lot more. What's going on? That proceeding is not just about his conclusion. It's about you preparing your defense. It's about the appeal. It's about the record. It's about so many more things. So it's just okay, great. I'll make note of your conclusion on the matter now, so that other people may also know, be able to make A, that conclusion themselves, and B, other related conclusions. We need to figure out the details, the information that's related to that topic.
So are you saying basically that I can jump to another question and leave that one just kind of sit on the sideline for a while?
No.
Because I'm not getting anywhere?
I'm sorry. I didn't mean to kind of imply that at all. I was trying to make clear that he was giving you his conclusion, and that's all good and well. But you're still trying to come by the information that led him to his understandings so that you can, A, make your own conclusion, B, investigate problems with that conclusion, C, be able to discuss it with the appellate panels, D, be able to show that there's a mistake, all these things, so many things.
Yeah, let me simplify what Garrett was just saying, because I think you're not quite getting. So I gave you an opinion. You're not looking for opinions. What are you looking for?
The facts.
Exactly.
So I would say objection, point of clarification, is it your opinion or hold on, there's got to be a better way to word that. Let me see.
Yeah, the point of clarification is your judicial notice of jurisdiction simply your opinion, or is it based in facts in evidence?
Okay. Yeah.
Arbitrary.
Yep.
Arbitrary opinion. Okay, so objection, point of clarification, is that judicial notice your arbitrary opinion or based in facts with evidence?
Based on facts in evidence. Or if you want crystal clear but longer.
Wait a minute. There was some language problem there still.
Was there?
Is that judicial notice your arbitrary opinion? Or judicial notice of your arbitrary opinion? There's a missing word in one way or the other. Are you taking judicial notice of your opinion, or are you taking judicial notice of some fact that you're calling something else? Judicial notice isn't an opinion in any context. Judicial notice is of something. Is that judicial notice a notice of your opinion, or are you taking notice that you have an opinion, or are you taking notice of some fact that you've not yet mentioned? Yeah, I'm trying to clarify that it's a communication about something, or the communication is something, and we're dancing around the difference.
Right.
And one way is right, and the other way is kind of wrong. And if it's wrong, a judge who's trying to throw you off can screw you around backwards with it by saying, "Well, I'm not quite understanding you. Well, judicial notice is just the taking notice of something. It's not an opinional thing at all." You know what I mean? If I was being an asshole judge, I'd totally pounce on that verbiage and get you spun around.
And they will.
Right.
It's kind of like, are you taking judicial notice of the presumption of jurisdiction, or are you taking judicial notice that you have an opinion of the presumption of jurisdiction.
Yeah. Yeah, we'll
Okay,
whittle
so-
at this. We'll get it clear.
Yeah,
Yeah.
it can be whittled better. It's there. It's just not, clear.
Yeah, we gotta get some rough edges off this, definitely. Good point. I mean, that we need, that we're just demonstrating that we need to get some better phraseology to this, or some good analogy to it. But that's how we develop those good analogies, right?
God, that's such a fucked up, like, not even that's like a non-answer. That's basically like saying, fuck you,
Right.
and blueberries are good, and I don't give a damn.
Yeah,
Yep.
because any
And this is
time
why
you fuck up
I
a
chose
phrase,
it.
they jump on it, right? Okay, so kind of thinking of it as I am taking a cognizant awareness of a fact. Is that word any better? It's probably not. I am taking a thoughtful recognition. There we go. Judicial notice is a synonym for a thoughtful recognition of a fact. When you say, is that thoughtful recognition your opinion? It's like that sentence goes a little bit weird. So is that recognizing, are you thinking and recognizing your own opinion, or are you thinking and recognizing some fact that you haven't even mentioned?
So you could say, objection, point of clarification, Judge. Are you thoughtfully recognizing your
That was
opinion?
my own.
or-
I was just coming up with a synonym so that we can better understand the words. We would use it in court,
I have something.
please.
Objection, point of clarification. What do you mean by the matter of jurisdiction? Is that some fact that you're taking notice of?
Okay, well, yes, sir. The fact is that we have jurisdiction, and it's a common knowledge. Some people think a fact is just an opinion that they really, really strongly hold, and that is super, super common in everyone. Everyone tends, except for people who are really into philosophy, everyone tends to think that an opinion that's super passionate is a fact. And that's a fact, Jack,
Right.
And we're playing with that verbiage, and he's trying to use that common mistake, that common vernacular against us.
Right.
And,
Right.
And he's like, that is a super strong, super duper opinion, and I'm taking a judicial notice of it because it's a fact,
Right.
So we've got to get around that idea and say, I'm sorry. Let's dispense with let's dispense with this bullshit thinking that an opinion can ever become a fact, and that's what we're working on.
It's almost one of those where I want to ask, I'm sorry, are you taking judicial notice of something you don't have the facts to support?
Yeah, I have an opinion that you haven't even bothered to worry about facts, concerning. That's a little combative, though, right?
Yeah.
Or are you taking judicial notice of an arbitrary opinion or fact?
Yeah. Yeah, you're taking judicial. I mean, technically, we know he's taking judicial notice of his conclusion that was based on no facts, at least no facts that were made public, right?
Is it your position that your opinion, if of judicial notice, is fact?
That's actually not too bad. It's not too
Yeah.
bad because it does bring up the point that he's trying to conflate opinion and fact, right?
Right.
Like you can just say, I've never heard of anybody taking judicial notice of an opinion before. What do you mean? Yeah, what does it mean when you say judicial notice in reference to an opinion rather than a fact? It must have some other definition.
Or I might say, how can you take judicial notice of an essential element of a prosecutor's burden?
Well, again, you're asking him. He says, "Watch me. This is how." I'll write it
Yeah.
pretty
down.
much. Pretty much, that's how he replied. This is exactly how we're taking judicial notice.
Bailiff,
you noted him.
bailiff.
Asking a how question is not a good question to ask because they're going to tell you exactly how they're doing it, right? So don't ask a how question if you can help it.
Yeah.
Right. Exactly.
I mean, judicial, right? He's claiming to be judicial. So if I was on the opposite end of the spectrum and I wanted to and input my own term in there to describe my opinion, I could say, and maybe to help people like, or me to wrap my brain around it, like, okay, I'm going to make personal notice of that.
Oh
Right?
wait.
That's all he's really doing.
Well, no, you can judge things for yourself too. There's nothing stopping anyone from judging things.
Like, well, that's
So-
okay
so,
because I take
another
judicial
question?
notice that it doesn't exist.
Yeah. So it's like I'm sorry. Are we now able to take judicial notice of opinions?
It's just a
Like I hereby take judicial notice that it doesn't seem that the prosecutor has any evidence supporting jurisdiction at all.
So if he says he's taking judicial notice, okay, and I were to put that and say I'm taking personal notice, then what I would say is like, okay, basically it's like you're saying, I'm going to take notice of matter. So I'm going to pay attention, which means that, like, I'm going to make note of that. Okay, there. So like you just gave like that's such a non-answer. Like it's like,
Right.
hey, did you want to watch SpongeBob? Oh, I'll make a note of SpongeBob. Like what?
Yeah. To take notice of something. I mean that's pretty. I mean it's kind of highfalutin English, but it's still there, right? Take note of this. Take
It
notice
doesn't
of
mean
this.
you're going to do anything though. That's the point I'm trying to make. It's not like a verb of, it's just a.
It is about a
Doesn't-
thought. It is about
Change-
contemplation, right?
Exactly. It changes absolutely nothing. It's like, oh, I noticed the sky was blue today, and so nothing's going to change.
Right.
I'm going to continue.
But he's making you aware that someone made him aware of something, and he's taking notice of it, and he's informing everybody that he is aware of it. That's what he's doing. He's saying, I'm making everybody aware of a fact that is so commonly known that it's not even really worth arguing about. It's
Yeah,
not
hold
that
on,
it
I gotta-
can't be argued about. And he's trying to imply that it's beyond argument because it's well known. And the problem is, here we are, pointing out that it's not known at all.
Hey, so this might help here. I just looked up judicial notice in Black's Law, and the last two words are the key words. But so judicial notice, evidence in some cases without hearing or inquiry is accepted by a court. It is typically a well-known or notorious or indisputable proven fact.
Right. Right.
So it's like,
Yeah,
well, if it's
it's something that's been proven to be true so many times that it's considered a waste of time to dispute it.
I guess a short way to short circuit that would be like, if it's a proven fact, then there should be evidence to support that fact.
Yeah, all I'm trying to do is get a copy of that proven
Yep.
fact. That's it. And it doesn't even have to be in court. We can do it out in the hall.
Objection, point of clarification. Are you saying that jurisdiction is indisputable?
Yeah. Are you saying that no American court has ever taken any dispute over jurisdiction? So if I file a case against you right now in this court here, that you would not be able to dispute jurisdiction. Is that what would be the case? Knowing what's in your heart and what they're pulling and how, kind of flushing out what you're looking at. I mean, that's 90% of what the phrasing could be,
It's one of those, well, when you're saying judicial notice, you're saying that it's a indisputable proven fact.
Mm-hmm.
And I am, in fact, disputing that. I would like to see evidence of that, quote, proven fact.
And furthermore, I am disputing it on the grounds that I've seen no evidence whatsoever of it.
I'm disputing on the
Sure.
grounds that I have never in my life seen someone show jurisdiction in facts.
Wait. Oh, okay. So show again. Okay, we have this phrase coming up once in a while. Show
Yeah,
me
show.
jurisdiction.
Yeah.
Show me jurisdiction. I'm having some trouble with that phrase. Okay.
Shown evidence, how about that?
Jurisdiction. Yeah, that's much better because I mean, show me evidence of jurisdiction is not a physical thing. Show me evidence of the number 5. You know what I mean? It's not a physical thing. Jurisdiction is a conclusion.
Well, it kind of is, isn't it? A gun?
Well, I mean, if you're going to get poetic about it, we can go anywhere, right?
Right. No, but I get what you're saying, though.
Yeah, and it's like, I'm sorry, you seem to be very confused, Mr. Defendant. Jurisdiction is not something you get shown. It's not a physical thing at all, and it's it's a legal matter and a legal issue, and if all we can do is show you, you're asking for something to be shown that can't, be seen.
Like, sorry, no, I'm just asking for the evidence that shows it to be true.
Correct. Yeah, we abbreviated it twice. So we went from shows it to be true, the prosecutor's claim of jurisdiction to be true. We shortened that to evidence of jurisdiction, and we shortened that and show me jurisdiction. It's like, we're over shortening, I mean, slang is not a good thing here. Show me jurisdiction is not good unless you're on Family Feud.